Hello, my dear students. Under labor law, first paper, today we'll talk about the unfair labor practices. This is unit number 3, and we are discussing Industrial Disputes Act 1947. And today we'll talk about the unfair labor practices. This is video lecture number 29. Section 2RA of ID Act, Industrial Disputes Act, talks about the unfair labor practices. Any of the practices is specified in the 5th schedule, chapter 5C. Under section 25T, provision of unfair labor practice that no employer or workman or a trade union, whether registered under the Trade Union Act 1926 or not, shall commit any unfair labor practices. So there is a provision on this, that no employer, no workman, or a trade union, registered or not, shall not commit any unfair labor practice. And under section 25U, penalty for committing unfair labor practices. Any person who commits any unfair labor practice shall be punishable with the imprisonment for a term which may extend to 6 months, or with a fine which may extend to 1,000 rupees, or with both. So there is a provision on the unfair labor practices on the part of the employer, on the part of the workman or the trade unions. And if any employer, any workman commits so, indulge in any unfair labor practice, then there is a penalty provisions for committing unfair labor practices, and would be fined, and there is a provision for the imprisonment also. Unfair labor practice for the first time was defined and codified in the Maharashtra Recognition of Unfair Labor Practices Act 1971, but insofar as the Industrial Disputes Act central law is concerned, unfair labor practice was codified and brought into force by the Amending Act 46 of 1982 with effect from 21st of August 1984. So this is what we are talking about, a brief history of the unfair labor practices when it was defined and codified. Clause RA of Section 2 of the Industrial Dispute Act defines unfair labor practice to mean the practices specified in the 5th schedule, and the 5th schedule was also inserted by the said amending act. The 5th schedule has 2 parts. The first part refers to the unfair labor practices on the part of the employers and trade union of employers, and the second part refers to unfair labor practices on the part of the workmen and trade union of workmen. So clause RA of Section 2 of Industrial Dispute Act defines unfair labor practices, which mean the practices is specified in the 5th schedule, and the 5th schedule was also inserted by the said amending act. The 5th schedule has 2 parts. The first part refers to unfair labor practices on the part of the employers and trade union of employers, and the second part refers to the unfair labor practices on the part of the workmen and trade union of workmen. Any unfair labor practice within its very concept must have some elements of arbitrariness and unreasonableness, and if unfair labor practice is established, the same would bring about a violation of guarantee under Article 14 of the Constitution. Therefore, it is axiomatic that anyone who alleges unfair labor practice must plead it specifically, and such allegations must be established properly before any forum can pronounce on the same. So, anyone who alleges unfair labor practices must plead it specifically, what is the unfair practice, and such allegations must be established properly before any forum can pronounce on the same. Now, my dear students, we would discuss the unfair labor practices on the part of the employers and the trade unions of the employers, or the associations we call of the employers. So, the unfair labor practices on the part of the employers and on the part of the association of employers. To interfere with, restrain from, or coerce workmen in the exercise of their right to organize, form, join, or assist a trade union, or to engage in concerted activities for the purposes of collective bargaining or other mutual aid or protection. That is to say, clause A, threatening workmen with the discharge or dismissal if they join a trade union. B, threatening a lockout or closure if a trade union is organized. So, if they're threatening a workman with discharge or dismissal, employer is just threatening the workman that I will discharge you, I will dismiss you if you, I find you indulged in any trade union. Or while the employer is threatening for a lockout or a closure if a trade union is organized by the workman. Or granting wage increase to workmen at crucial periods of trade union organization with a view to undermining the efforts of the trade union organization. This would also be treated as unfair labor practices. And to dominate, interfere with, or contribute support, financial or otherwise, to any trade union, that is to say, an employer taking an active interest in organizing a trade union of his workmen, and an employer showing a partiality or granting favor to one of several trade unions, attempting to organize his workmen or to its members where such a trade union is not a recognized trade union. So all these things would be treated as an unfair labor practice on the part of the employer. And then next one is to establish employer sponsored trade unions of workmen, because sometimes what happens, employer, they sponsor the trade unions and they use these trade unions for their benefits. So this is a kind of unfair practices under the act. And next one is to encourage or discourage membership in any trade union by discriminating against any workman. That is to say, discharging or punishing a workman because he urges other workmen to join or organize a trade union. So if any workman is just urging or requesting someone to join, or requesting someone to organize a trade union, and on that ground, if the employer is discharging or punishing a workman, would be treated as unfair labor practice on the part of the employer. And discharging or dismissing of a workman for taking part in any strike, not being a strike which is deemed to be an illegal strike under this act. So if the employer is discharging or dismissing any workman uh, on the ground that the workman has, participated, or he was the part of the strike, and this strike was not an illegal strike. So this would be again treated as an unfair labor practice on the part of the employer. changing seniority, rating of workmen because of the trade union's activities. So, as a punishment, the employer is changing the seniority or the ranking of the workmen. This is again, would be treated as a unfair labor practice on the part of the employer. Refusing to promote workmen to higher posts on account of their trade union activities. This is again unfair practice on the part of the employer, unfair labor practice. Giving unmerited promotions to certain workmen with a view to creating discord amongst the other workmen or to undermine the strength of their trade union. And discharging office bearers or active members of the trade union on account of their trade union activities. So this is again would be treated as an unfair labor practice on the part of the employer. To discharge or dismiss workmen by way of victimization or not in good faith but in the culpable exercise of the employer's right, by falsely implicating a workman into a criminal case on false evidence or on concocted evidences or patently false reasons. So all those ground means activities would be treated as unfair labor practices. Or if the discharge or dismissal of a workman is on untrue or trumped up allegations of absence without leave, or in utter disregard of the principles of the natural justice in the conduct of domestic inquiry, or with undue halt. So, because sometimes what happens, employer is conducting some sort of inquiry, and while this domestic inquiry is going on, then the principles of natural justice is being ignored by the employer, then it would be treated, or some with undue halt it is, then it would be treated as unfair labor practice on the part of the employer. And if the workman is being discharged or dismissed for misconduct of minor or technical character without having any regard to the nature of the particular misconduct or the past record or service of the workman, thereby leading to disproportionate punishment, would also be treated as unfair labor practice on the part of the employer, I beg your pardon. And to abolish the work of a regular nature being done by workmen and to give such work to contractors as a measure of breaking a strike. This is again an unfair labor practice on the part of the employer. To transfer a workman main fight from one place to another under the guise of following management policies, and to insist upon individual workmen who are on a legal strike to sign a good conduct bond as a precondition to allowing them to resume work. So all those things, I mean, after the strike, once workman is coming to perform after legal strike, and the employer is just compelling to sign a good conduct bond as a precondition to allowing them to resume work, would also be treated as unfair labor practice on the part of the employer. And other one is to show favoritism or partiality to one set of workers regardless of the merit, would also be treated as unfair labor practice. To employ workmen as badlis, casuals or temporaries, and to continue them as such for years with the object of depriving them of the status and privileges of permanent workmen, or to discharge or discriminate against any workman for filing charges or testifying against an employer in any inquiry or proceeding relating to any industrial dispute. So all those matters would be treated as unfair labor practices on the part of the employer. The other one, like to recruit workmen during a strike, which is not an illegal strike. This is again unfair labor practice. And failure to implement award, settlement, or agreement would also be treated as a unfair labor practice on the part of the employer. And to indulge in acts of force or violence, to refuse to bargain collectively in good faith with the recognized trade unions. And last but not least is the proposing or continuing a lockout deemed to be illegal under this act on the part of the employer, and would be treated as unfair labor practice on the part of the employer. So this is what the unfair labor practices on the part of the employer. My dear students, now we'll just discuss some points related to the unfair labor practices on the part of the workmen and trade unions of the workmen. So the number one is to advise or actively support or instigate any strike deemed to be illegal under this act would be treated as unfair labor practice on the part of the workmen or the trade unions. To coerce workmen in the exercise of their right to self-organization or to join a trade union or to refrain from joining any trade union, that is to say, for a trade union or its members to picking in such a manner that non striking workmen are physically debarred from entering to the workplaces. This is again unfair labor practice on the part of the workman. To indulge in acts of force or violence or to hold out threats of intimidation in connection with the strike against non-striking workmen or against managerial staff. For a recognized union to refuse to bargain collectively in good faith with the employer is also unfair labor practice on the part of the workmen or the trade unions. And to indulge in coercive activities against certification of bargaining representatives and to stage, encourage, or instigate such forms of coercive action as willful go slow tactics or squatting on the work premises after working hours or gherraus of any of the members of the managerial or other staff. All those things would be treated as unfair labor practices on the part of the employee. To stage demonstrations at the residences of the employers or the managerial staff members would also be treated as unfair labor practice. To incite or indulge in willful damage to employers' property connected with the industry, and to indulge in acts of force or violence or to hold out threats of intimidation against any workman with a view to prevent him from attending work. So all these things would be treated as unfair labor practices under the Industrial Dispute Act 1947. So this is all about the unfair labor practices on the part of the employee, on the part of the employer, and there are penalty provisions, there are punishment provisions if any employer and any employee is just indulging into the unfair labor practices. So my dear students, I hope that today's lecture will help you and will give you an insight about the unfair labor practices given under section 2RA of the Industrial Dispute Act 1947. Thank you so much for your patience listening, and in our next lecture we will take up some new topic under Industrial Dispute Act 1947. Thank you so much, my dear students. Have a nice day, have a nice time. Thank you. Bye bye. Take care.